Thank you for joining us today. I'm Henry Karras and Renee Petula, and we're here to have a chat with you today about medical negligence. And in particular, we're going to discuss a subject that's quite difficult for people to understand, but it's important for them to understand when it comes to medical treatment, and that is the concept of the loss of chance. And it's the loss of chance of getting a better outcome if a doctor or a hospital had done the right thing. And so that's our subject for today.
So Henry, could you explain what does loss of a chance of a better outcome actually mean for people out there that are sort of grappling with this kind of area of law?
Well, Renee, look, it usually starts with someone who's very disturbed by facing probably a really difficult medical setback because they think a doctor did not do the right thing to give them a better chance of an outcome. If they had done a diagnostic test, maybe referred them to a specialist, maybe followed up on a procedure, their situation would have been improved, and they're thinking any chance to get an improvement would have been helpful. And now that they've lost that chance, they want to know whether they can get compensation for the adverse outcome that they now have to live with. That's the way I would sum it up.
Yeah, so that's really helpful to hear your explanation. So if someone has lost that chance and they could have had a better medical outcome occur, can they actually pursue a claim?
The law will give them that chance. Funny I use that word. The law will give you that chance, but you have to prove that it's a substantial chance. And they want it in language that they would say is appropriate. They want it in the language that says you had more than likely, by the preponderance of possibilities, a chance of the better outcome. The way that converts for the average person, and the easy way for them to understand it, it has to get past 50%. It has to get past a 50-50 chance. So if you can get to 51% chance of getting the better outcome, the law will assist you with compensation. But if your doctors and your experts and the medical evidence seems to suggest it was only maybe a 10% chance or a 20% chance of a better outcome, the law in Australia will not come to your assistance.
So we often have people call our firm in regard to delayed diagnosis of cancer. So in that circumstance, if the cancer could have been picked up earlier and perhaps treated and resulted in better outcome, would you say that that kind of claim is something that would fall into this category?
It could. Again, you'll need the expert evidence from appropriate expert oncologist, a person who deals with cancer, indicating that the treatment, if provided earlier, would have provided a better outcome, more than a 50% chance of that outcome being achieved. And the difficulty lies for many people with cancer is that lots of times the outcome is still achieved. It could have been just they have to suffer for a longer period of time, or they're left with a concern about their future. So there's a lot of difficulties with a type of claim dealing with loss of chance. You've got to establish that you actually have lost something, and then that loss has to be greater than a 51% chance of it.
Yeah, so you do mention that it is quite a sort of a difficult, complex area of law. So what kind of evidence would someone need, or would our firm need, to be able to produce and show in order to help the client be successful in one of these claims?
You start as a researcher, really, Renee. You start with taking as much information you can from the client, knowing that even their memory at times can be slightly skewed because they're upset about what's happened to them. So you take their information, and then you look at the medical records. So you get the hospital records, the doctor's records, and you start to create a chronology of events. And when you start to see what's happened, you get an idea of whether or not there is a loss of a chance, even argument. If that argument can be raised, in other words, you're thinking the diagnosis could have been made earlier, the referral could have been made earlier, the follow-up could have been done sooner, then it has to turn from you, the lawyer, to an expert medical practitioner in that area of law to comment, to say whether or not that treatment that's been suggested, provided earlier, would have improved that person's chance of a better outcome, improved it by 51% or more, and then what that outcome would have been.
It's really interesting. Thanks for giving us some information on that today. And if someone has any questions about how to pursue one of these claims, what would you sort of suggest is the next step for them?
They shouldn't live in doubt. That's my first comment, Renee, because that's the worst state to be in, to be concerned about whether or not you actually received the right medical treatment. That shouldn't exist. So Firms like ourselves, we work on what's called a no-win, no-fee. We're here to help you. We'll take your instructions, we'll do the research for you, we'll find out whether or not you do have a claim or not, whether or not you did lose that chance. And if so, then there's compensation to assist you with that. And if not, at least you'll understand that that doubt or that risk didn't really exist. That would be my thought.
Great, thanks for that, Henry.
My pleasure. Have a good day.